Good evening and welcome to Slam the Gavel, the show that tells it all regarding family court, other court issues, as well as CPS. I'm your host, Maryann Petri. There is a non-denominational retreat weekend at the Resolution Center of Jacksonville, Florida. This will be a time of support and renewal for parents and grandparents on the journey of parental alienation. Standing strong in resilience, paving the way for good health and a great future. This will take place April 22nd, through the 24th, and I will put the link in the podcast notes. I have a return guest. His name is author Michael Sayen, and we're going to talk about why we can't just get along. Why
That's right.
can't we? Why can't we get along, Michael?
Why can't we all just get along? Get along, little doggies.
Yes,
All
and
right.
you were on my podcast last October 28th, season 2, episode 120.
Right.
And you've been on my podcast multiple times. I'm glad to get you on this evening.
Thank you. Hey, thanks. It's a pleasure and an honor speaking with you. You and I always have good conversations.
Definitely. So you're going to tell us why we can't just all get along.
Why
This
can't
is a
we
big
just all
mess.
get along? Yeah, no, right. And it has been a catastrophe, right? It has been a catastrophe. It has been a dog in, dog out fight for the past 200 years. Especially with the Western culture. So I'll go ahead and explain to you. First of all, I wrote a book, Remarriage and Adultery in the Bible. It looks at the Jewish historical precedents of marriage, divorce, custody issues in the Old Testament, how it was brought over to the New Testament, how the Jews were under Roman occupation. So they had the Greco-Roman law, which was actually changing at the time of the Jews where they had occupation over the Jews, and the ancient Israel Jewish marriage practices. So we're going to look a little bit of the historical rabbinical practices, and then kind of how that whole, believe it or not, the whole the not only cultural war, but the war between the sexes that was started in Rome and Jerusalem under the bride prices and the freedom of women from bride prices and dowry and sex slavery, and how we're actually just repeating ourselves 2,000 years later.
Mm-hmm.
So I'll let you start off with any questions you have.
Yeah, it's just, the coverture, like I don't understand the coverture leading into feminism and contract law.
Yeah, so feminism is nothing more than a pushback against coverture laws, right? Coverture laws said that it was a French word, covert. I can't pronounce it correctly, but basically that the woman would lose her legal identity. Now that actually came from scripture where the woman became flesh of his flesh, Adam, bone of his bone. So what they actually, coverture says is that the woman loses legal identity of herself. She actually falls under that of her husband at common law. Now that all started with the Anglo-Saxons going in the 10th century into Europe. And so Europe just adopted that from the Anglo-Saxons in like early 10th century. And they just continued with that ever since. Now the Church of England, right, we hear about the separation of church and state here in America, but with the Church of England, right, we're looking at the Pope being about as powerful as a king. I'm sure you could hear different historical references, but basically the expansion of the Roman and Catholicism and the power of the Pope. And the Pope became more of a political figure. Now, so when you look at it, the Church of England was in charge of all the divorces and the basically legislation through the I always get the name of this wrong. Ecclesiastical. I can't say it. Ecclesiastical. I can't say it. Courts. So I'm just horrible. I don't know why I can't say it words. But basically, it was the courts that were designed through a canon law, and that was basically the law set forth by the Church of England. Now they handled all divorce issues. So divorce issues has always been handled through religion or the church. Right. It is, and it's usually been accepted through civil law. Now that's historically, right? So it's usually it starts with tradition, it starts with the family, it starts with religion, and then it kind of ends with the state. That's how kind of historical through many different nations and thousands of years of history. That's for the most part of how that kind of happens. So religion and society kind of deemed what was proper and what was not proper in regards to marriage, divorce, custody, patriarchy, monarchy, matriarchy, egalitarianism, feminism, all that stuff. It was really just run under the whatever religion. I mean, it was the Jews, conservative Jews. It was the Muslim under Sharia law, Christians, Catholicism, Catholic law, canon law. So you have all these kind of laws and doctrines all meshed together. And what it is the people kind of choose how society is kind of run. Usually that is instituted by the push of whatever religious institute. So the religion sets the boundaries for both society as well as men and women issues. Now, men and women issues have always traditionally started at the marriage ceremony. The marriage ceremony stems to set the precedence for the marriage. Now, so a lot of times, in most, I think 60% of the world right now does arranged marriages still today. That's where you'll typically see where there'll be prearranged marriages, there'll be bride prices, there'll be dowries. So 60% of the world. So now we have our Western marriages, which is only predominant because we're kind of monetarily dominant. And so we're kind of leading the world. But remember, whenever you're dealing with marriage, divorce, and custody, you're dealing with two separate entities. You're dealing with religion of whatever territory, society, or nation you're in, and then well as civil law, right? What society is deemed non-religious, but what society or the legislation in that particular, or the laws in that nation, what they deemed was appropriate. However, it was usually hands-off, right? It was usually the two people would get married and then they would report that marriage to the state, right? We see that in Joseph and Mary, right? Joseph and Mary, they were betrothed. They went to Bethlehem because of the censorship, and so where Jesus was born. And then they had to, and they went there because the censorship wanted to know the birthplace and all this other stuff. So it all had to do with you just basically reporting your marriage and then them just basically putting it on record. And that's, for the most part, that's kind of how it's been dealt with here in America as well. Now, it's been changing. Now, the change actually instituted, as I mentioned, coverture started around the 10th century and before the 10th century, but England adopted it in the 10th century. Now, America law is through English law. So we kind of get our precedents through English law. We get what's called our common law system through England. So a lot of whatever England is practiced, even though, and this is where it's important to also understand, right? When you're understanding authority, superiority, or what's called the Leviathan doctrine, or is that the Leviathan principle? That's where the king was supreme, right? The king had supremacy in England. So the government had supremacy. People did not have supremacy. However, when America, we adopted English law here in America, but what we did is we flipped the supremacy, keeping a lot of the English law though, and we started to say, well, we the people are supreme, right? The supremacy is with the people and the states, right, in the 10th Amendment. And then the enumerated powers, if it had to be delegated through the Constitution. Anything that was not delegated through the Constitution for the federal government belonged to the states and the people. Now, unfortunately, most courts have thrown out "and the people," and they say anything not delegated specifically through the Constitution is for the federal government and the states, and they just throw out the people. However, people don't realize is that the states' constitutions existed before the federal constitution, right? So in the state constitutions, they gave the people rights, or they didn't give the people rights. They acknowledged their rights, or the inalienable rights. So what happened was, if the states, before the federal constitution came, the states said, hey, we the people have inalienable rights. So that's how come a lot of people believe, historical people believe that the 10th Amendment was written in such a way saying that the powers to the state and the people is because the people were already guaranteed rights in the state constitutions. So basically it was for the states and the people to decide for themselves where that dividing line landed. And the thought is the reason why states had constitutions, because if you didn't like where the dividing line was, where the power of the state and the people began and ended, you could just leave that state and go to a different state. So that was the original intent of saying that, hey, it's you're not, it's not finite. You could just leave a state and go to a different one who had different constitutional rights given to we the people. Do you have any questions on that so far?
Oh, it just revolves around Great Britain. Like the
Yeah.
Bar Association. It just everything is. I thought we had detached ourselves from Great Britain with the Revolutionary War. Apparently, that didn't happen.
Well, yeah, and that's important to understand is that what we did is we adopted their laws, right? We adopted their common law system, right? Common law system was really most part or famous through England, if it was not originated through England, through the traveling courts, right? The traveling courts in England, in early English history, what happened was they didn't have a way to correspond with one another. So when the traveling courts would travel from one town to another, to be able, because they didn't have what was called statutory or codified law, the courts made the law, right? And they made it through common law or through case law. They make a decision, and they go to the next town, and they would say, well, according to Brown versus Brown, if a horse was stolen, it was the value. This is how we did the values. Therefore, if we bring it over to this town, what it did is it created, without a codified law like Roman law, what it did is it created a way for the law to be flexible. But the king was the one who actually appointed the judges for these traveling courts. So what happened was the king realized that if he could control the judges, which is happening here in America today as well, but if you could control the judges and appoint the judges, you can control the legal system. And so he was able to the king actually became very, very rich through the traveling courts or the common law system, because he was able to taxize the people. Now the Constitution really came from the Great Charter, which we call in England they call it the I forgot the name of the document for some reason. It's the original name is called the Great Charter. It's the famous document. For some reason I can't think of the name. I'll think of it in a second. But basically, the lords of the people rebelled against the king. Said, "Hey, you're using the judicial system for your own good. You're creating laws through these traveling courts, and then you're taxing the people, or taxation the people through these courts." And he was getting great power, and they said, "Well, wait a minute. We want a declaration of rights to be able to say that, hey, we have rights here." So the lords or the landholders of England actually forced the king to sign this Great Charter under threat of knife. That I talked to you about that before briefly, but basically the king did that. But that actually became the precedence for the Constitution. The Constitution is basically saying that they're human. It's a human rights document, saying that, hey, these are the human rights of we the people, right? Not only does it flip supremacy and give supremacy to we the people with checks and balances, but it also says, and that's how we the people are able to survive, because the government's able to survive because what they did is the founders, right, the authors of the Constitution, and they actually said that, hey, we know that power corrupts, absolutely. So absolute power corrupts absolutely. So why don't we go ahead and create a system where we actually depend on people to be selfish, and by creating a checks and balance system, right? If the executive power becomes too big for his britches, then what would happen is the legislative branch would come in, the Senate or the House, and they would be able to have that veto power. And because nobody wanted to give power to somebody else. So the whole checks and balance system isn't working under the premise of, hey, let's all get along. It was based on a premise of, hey, we're hoping that each, the legislative branch or the executive branch, the House or the Senate, would be so selfish that they wouldn't want to give any of that power away. Now, the judicial system, when it was originally created, and we can see this through the Federalist Papers, the legislative system, when it was originally created, right, that third branch of government, that actually wasn't supposed to have that much power. But what happened was Marbury versus Madison, they actually extended themselves power, and they gave themselves the power, which we call judicial review. And the judicial review, I believe in 1803, said that, hey, if it's regarding matters of constitutional issues, we have the ability to veto executive laws as well as legislative laws. So what they did is they deemed themselves not only the judge, between matters of legislative and executive branch, we the people and the government, but they as umpires, what they were called, umpires. But they not only gave themselves, but they also gave themselves the final word, the final say. So in a sense, people could say that judicial power in itself, by the judicial review, actually is the greatest of the three, or the most powerful of the three branches of government today. Now, the problem is that we're in a broken system where the executive branch and the legislative branch, they're not really listening to the Supreme Court decisions. But I don't want to go on a sidetrack. But so we got this system. Now, the system was an experimental system, right? The United States' governmental system, it was really all just an experiment, right? It's called the Great Experiment. Now, what happened was, originally, to be able to understand the gender war that we're in today, we need to understand a little bit of the men and women issues. So this is kind of a little bit where I specialize in my study. Now, there's different religions, but most all religions usually start, now that you're looking at 90, 95, if not more, right, start with a patriarchal system, that where the man, the hunter, the gatherer, right, the one who's physically stronger was the one who ruled the marriage, ruled the relationship. Now, feminists or true feminists will tell you that they don't believe in the institution of marriage, because they believe it's an institution, and they believe that egalitarian principles or feminist principles, or you can't be a feminist in a marriage. And so they actually don't like marriage. Most feminists, true feminists, when they originally started, I believe it was Feinstein, I can't remember the name, but they actually said that they wanted to destroy the marriage itself. Now, Marxism, which started in 1917 in Russia, they also believed in destroying the family and marriage, because they believed if you destroy the marriage, you destroy the family, the government will be able to take control over the children through the wife. And so actually no-fault divorce was created in 1917 under Marxism. Now, no-fault divorce actually started in Rome in the first century AD, under Greco-Roman law, and that was the rule of thumb for Rome is that a woman, though for 600 years she fell under what was called coverture property law because of the bride price, so she fell under the full authority of her husband. However, they created a new legal system where a woman could say, well, I don't fall under the legal authority of my husband if I'm married. I actually fall under the legal authority of my father when I'm married. So they still said, so they believed in a patriarchal system, not through the husband, but through the father, or the heads of the clan. And so the woman believed that she could rebel against her husband and in Greco-Roman law and divorce her husband and do all these other things against her husband, because on the first century AD is that or the first century, because she would say that, hey, I fall under the authority of my father, and my father has the authority to supersede my husband. Now, that's the reason why, and that's where no-fault divorce really originated from, and so women were really starting to divorce like crazy. Now, that you kind of open that floodgates, right? You give women the permission to divorce after having patriarchal rule for 600 years, and the women went crazy with divorce. Now, the same thing had happened in Russia under Marxism, and when no-fault divorce was implemented, it was 5-to-1 ratio, 5 divorces for every one marriage. And that was 1917 and 1925. So under, like I said, Karl Marx. So what we did the same thing, right? And we did in 1969, we had no-fault divorce. As soon as no-fault divorce was given, well, women, I'll back up a little bit more. So women were not allowed to really legally, as they were legally considered one with the husband. And basically how it worked is that they would lose their legal identity. They actually became the legal extension of their husband. So they would lose all legal identity. Now, when they lost all legal identity, that means that they did not have constitutional rights, because they lost the legal rights. So as far as when you're looking at the 1600s, 1800s under coverture laws, women, children, and slaves none of those had constitutional rights. until the 14th Amendment. When the 14th Amendment, the Equal Protection Clause came in, it gave rights to we have the slave amendments, 13th, 14th, 15th Amendment. It gave rights to the slaves, right, and abolished slavery, but it also gave constitutional equal protection and basically, more importantly, citizenship to the blacks. Now, it also extended, which was, they didn't really probably plan on it, but the women under feminist groups, second wave feminism, around 1875 or so. I'm not exactly sure when second wave feminism, but it's probably around that time. But what happened was they used the Equal Protection Clause of the 14th Amendment to say that, hey, if the blacks have freedoms, if they're citizens and they have equal protection under the law, well, we as women, we want equal protection under the law. The court started granting women that equal protection under the law. And one of the first things that the women wanted was they wanted the right to divorce under equal terms. So before the 14th Amendment, women were not able to, for the most part, initiate divorce. And also because women, children, and slaves were under property laws until the 14th Amendment, if a divorce happened, the father got 100% custody of the children. Now, when you're so what happens is you're going to start seeing is that, and to kind of back up even a little bit more when we're looking at the gender wars, because we're really under a gender war today. We're under gender war with the he, she pronouns. We're under war with transgenderism, homosexuality, with the Board of Education and what they're teaching our children. It's a flat out gender war today. That's how come my book kind of became a little bit popular. I started writing it about 25 years ago when we didn't really have a real big gender war. But right now we're in the midst of a gender crisis, a gender identity crisis. People don't know if, we have the Jeff Younger, right, where his 7-year-old son is identifying as a girl because the stepmother, this is not even the biological mother, kind of was pressing him. And so, Jeff Younger lost that battle. And then originally we're given a little bit more after it became public and Ted Cruz got involved. And then Jeff Younger, because of the pressure put on the judge, got a little bit more rights. But then they also threw a gag order on him, right? Because they don't want him talking about it. And so judges are trying to protect their butts with gag orders, right? Gag orders are nothing away. They say it's to protect the children, to protect the children's right, to protect the children's privacy. But no, gag orders, what is really to protect the judge from being socially deemed inept and as an abusive person, or actually abusing the children, really realistically abusing the children through the legal system. But this is not new, right? So what happened was, during coverture, men were giving 100% custody. Now, a famous lady on the early 1800s, 1820s, 1830s, it was Carolyn Norton. Carolyn Norton was a very prominent woman. She had very good friends in Parliament. She was a famous writer and author, poet. And she petitioned to Parliament, which you have to do in England, to actually to get a divorce. Now, at this time, there were only, in all of English history, so we're looking at maybe 600 plus years, there were only about 354 divorces in all English history for 600 years. And only 4 of those, I believe, were initiated by the woman. So to get a divorce, you had to go through the Church of England. Church of England did not believe, because of Catholicism, did not believe in divorces, right? Because that was a Catholic practice under canon law. And so they would have to petition a private act of Parliament for divorce. Now, Carolyn Norton petitioned Parliament, but was denied. But what she did start was something that her political influence that she did start was she started really feminism. And the feminism is nothing more than egalitarian principles that are pressing against oppressive men. Right, that was the intent, right? How do we push against oppressive men? So what's the very oppressive thing for women? Well, coverture law was. So what she actually deemed was that there was a human right issue with fathers because of breastfeeding and bottle feeding they didn't really have. So because of breastfeeding, she actually deemed it was a human rights issue for the fathers to get 100% of custody of infants, because men were not able to breastfeed the children. Parliament agreed. And so in 1830 they actually created something called the younger years, or the tender years doctrine. And then during the tender years doctrine, they gave 100% custody to the mother while she was breastfeeding the children, or until the child was weaned. Now, supposedly it was until the child was 4 years old, then it would go and live with the father after the child became weaned. However, that age actually got pushed back. I think in just like a year or two later or several years later, English law changed it from 4 to actually 16 years old. And in the United States, United States around 1850, most states, like individually, because divorce was handled through the individual states, federal government really wasn't involved. And most states around 1850 started to incorporate the feminist principles brought over from England on the tender years, the younger years doctrine. And they said, okay, hey, women were allowed to, were given, they already had some power to divorce, right? It was very hard to divorce. Like under the matrimony clause of 1857 under England, both men and women could divorce for adultery, but the woman had to prove that the adultery was continuous. And there was another added fact, like there had to be cruelty or abandonment. So she had to go, there was never a 50-50 equal way to divorce. And so women always had a hard time initiating divorces. And that was really and that really started because of bride prices. If you think about it, when you did a bride prices, they would consider the woman acquired or legally acquired. So she would fall under property laws because she was acquired as a slave would be acquired, right? You would purchase a slave. So with bride prices, in a way, the legal system was purchasing a wife. And when she was purchased, she lost all legal rights. Now, this is actually supported in scripture as far as slavery. And you'll see in the slavery about bond servants and Yom Kippur and releasing the slaves every 7 years is that, however, there was a problem with it when a slave got married and had children because the owner, right, the master or the owner was the man fell under property rights. So many times, according to biblical Old Testament law, you can see this in the Bible, several places, is that if a man was a slave and he had children and and the slave master gave him a wife, that his children and wives, he could leave at Yom Kippur every 7 years. So every 7 years they let the slavery free. But however, the women and children were still the property of the owner. Now, so a lot of these principles, really fell equal with coverture law. Now, according to coverture law as well as biblical law, and you'll see this in Numbers chapter 30, is that a woman never had independent authority to sign contracts and do a whole bunch of other things, and unless she was this is according to Numbers 38:9. It says unless she was widowed or divorced. Now, if you were not widowed or divorced, you were considered either under the complete legal authority of your father, right? And then Numbers 30:16 tells us as long as she was young, living under her father's roof, right? And so that's pretty much was a consistent act because women didn't have apartments back in the, in the Old Testament as well, right? So they couldn't just run out and get a job and get like that. And a lot of times, believe it or not, under coverture laws, women were not able to keep their own paychecks. And they could not get jobs without the permission of their husbands, both I know definitely in the United States. They weren't able to sign contracts, right? They weren't able to make a lot of legal things. So the women actually joined in the early 1800s, joined the freedom of slavery or the slavery movement, because as the slaves were saying, hey, we're people, we have unalienable rights promised to us in the Declaration of Independence. The women said, well, what about us? Yeah, we too. So they actually joined the slavery movement in the early 1800s. So the tender years laws came to America, right? First wave feminism started in 1840, right? You have 1850, younger years, tender years doctrine. You have around 1875, the 14th Amendment giving equal protection. And women basically given 100% citizenship rights when basically in 1920, when they were given the right to vote. When they were given the right to vote, they were really at that point considered to be full citizens, having the full right of men at that point. Now, however, coverture still existed until the 1960s, where a famous United States Supreme Court case actually said that that coverture is now obsolete. But that was not until around 1960, I believe, 1966, where coverture was not still practiced as a normal practice under the common law system, even in the courts in the United States. So it's always been, if this makes sense, basically, even though I'm trying to give you a sense of the diabolical, right? Of how messed up, how a gender war has always been gender war. Now the problem is that you and I were talking earlier before this show, is that so men were given 100% custody until the 1850s. Then women were given 100% custody of the children in the younger years. And then those ages started to fluctuate of which age is what actually age is the tender years? What age is the younger years? What age is that? And it started to fluctuate, right? 6, 7, 9 in the United States. And then what happened was they basically under a very well-known principle called status quo, is that the women said, well, the child has already been with me for, I had 100% custody, right? This is the early 1800s to the mid 1900s. They said, well, I've already had the custody. They got friends, they got family, they got a great education, they're doing really, really well. The other husband, her former husband, might have gotten married already with other kids and families, and they would just petition to the court and say, hey, under status quo, can I just keep the kids? So what happened was the women started to the courts kind of just started to forget about the men. And under the tender years doctrine, the children were just given full rights to the mother. Now so it basically flipped on its heels. It went from before 1850, man was given almost 100% custody all the time. And then after 1850, women were actually, like a couple of years later, women were given 100% custody almost all the time. And so it did an immediate flip. And this was based upon, and then the Equal Protection Clause really locked that in, right? Mm-hmm. So now men are starting to say, well, what about the Equal Protection Clause, right? If the women could divorce, if the women use Equal Protection Clause to be able to get the right to divorce, to be able to get citizenship, to get all the rights as men, and to be able to get our children, why can't we get under Equal Protection Clause? Why can't the courts make it equal? Well, as you and I know, under Title IV funding, as well as other things, is that whenever the government is involved, the government always wants two things. The government always wants power, and it always wants money. So consider that once it has money or it has power, it is historically is never easily given either of those two up. Long story short is that whenever a divorce happens, right, the children are what the legal system says, the children become wards of the state. What that means is that if you just sign a petition, the courts say, well, we have jurisdiction in your home now because we got to decide who gets the child. So now the jurisdictional power, you basically are inviting the government into your home. When the government's invited into your home, they don't just make a decision and then leave your home. The children become wards of the state forever, right? And until that child becomes no longer a child and is an adult. But then they have to start paying taxes and other things, right? So once you start a divorce process or even a petition for divorce under temporary orders, the courts consider themselves having the jurisdiction over 100% over your children. And because of that, the courts have also been able to monetize the situation, right? They've been able to use the situation. Now, you talked about the Bar Association. Now, the Bar Association really started in America around 1875 in New York. About 20 lawyers who actually started this Bar Association. And then by the early 1900s, 1910, I think it was like 75%. It was like large, like 75%. It was whatever it was. It was a huge amount of most of the lawyers were now under this Bar Association. The Bar Association is a certification. It's you get licensed through the state as an attorney, right? So the bar doesn't give you any license. The Bar Association has no authority on its own. The Bar Association is nothing more than a legal system that because it's it's a monopoly. So basically, under the monopoly system, they're really able to control, what lawyers know, what lawyers think. The education system of the legal schools, right, bringing the legal document, the legal books are printed through the support of the family division of the Bar Association. Now, the bar, when you understand lawyers and judicial system, you have to understand I got to remember, what was the Great Charter? What was that called in England? It was called the. Can you help me out?
Was it in 1066 with King John?
Well, yeah, but what was the document? It's a famous document everyone uses now. It's called the.
I know it too. It's like it's.
It's a famous document. I gotta look. One's,
Um,
what's it
I'm
called?
looking up to.
So look up the Great Charter, England, and then it'll be it's a super famous, well-known word.
Yes.
Uh, it's a premise of all human rights in the world. Oh my gosh, it's so
Magna
important.
Carta.
Yeah, the
Magna
Magna Carta.
Carta.
Yeah, the Magna Carta,
There
right?
I
The
am.
I think the Latin. Yeah, that's what I think. That's the Latin term for the Great Charter. Thank you so much. The Magna Carta. So the Magna Carta actually gave the human rights to the people, right? And that actually, I actually want to say Gandhi. I heard actually Gandhi was inspired by the Magna Carta. So now the Magna Carta are not giving rights to the people, but they acknowledge rights to the people. So they acknowledge the rights to the people. Now, the Constitution and the Declaration of Independence recognizes that those are the natural rights of God. God has given you those rights, and man is doing, or the government's doing nothing more than recognizing those rights. Now, so when you're dealing with custody, now the important thing is that when you're understanding about the gender wars, is that the Bar Association. Now, the Bar Association, when you look at the Magna Carta was to break up the authority that the king had over the people in the judicial system.
Mhm.
And so under the Magna Carta promised, which the Lords actually wrote up, is or the Lords for the landowners, it gave them the right to a jury, right? So
Mhm.
the jury said, hey, the power no longer belongs to the to the judge. The power belongs to we the people, right? So what it did is say, hey, we want to be judged by a jury of our peers. We want to be judged by people like us.
Mhm.
And that's, you hear about nullification and other things. But the most important thing is that was one of the most important, or the most important thing of the Magna Carta was jury. Now, the jury is promised in the Constitution, I think, for any matters over $20 or more. Now, family court was originally, or divorce was originally handled through the civil courts, and through that means that you actually had the right to a jury.
Mhm.
But what happened was in the juvenile courts in the late 1800s, I think around 1875 is around again, 1890, is that according to different states at different times, they actually said, well, we want to get rid of the jury, and so they incorporated a court practice in Europe called the courts of equity from the chancery courts, and they basically said that, hey, under the chancery courts, the courts of equity, juvenile courts, they didn't have to have a jury, right? Because the children were wards of the states, and they didn't have constitutional rights because they're under the property laws. And so property laws of the children started to dissipate under the 14th Amendment. And that's where children now are no longer considered property, or not even part and parcel of the constitutional rights of the parents. Now they're actually considered the wards of the state,
Mhm.
and dependents of the state. And so the government now, under the parents portray doctrine, is saying that, hey, we are the parents of all the children, right? So the parenthood, when coverture law was destroyed, and this is where feminists didn't plan on, when coverture law was destroyed under the 14th Amendment and the Equal Protection Clause, women wanted the equal rights to the children. But what it did is it invited the government into the family, and the government usurped 100% authority over those children, and said that parents are nothing more than guardians, right, of those children. But those children belong to the state. And they incorporated the parents portray doctrine, which is in 1608 from England, and that was when the king said, well, hey, children, right, the nation is the parent of the child, or the children, and that actually came, believe it or not, historically, that I think that was like a 300 BC term when you're dealing with Caesar, when he would be considered the parent of the nation, right? He was the father of the nation, or the fatherhood, right? The father of the nation. And you'll hear that, and that was basically the parents portray doctrine incorporated in 1608 England. But however, when America took over the parents portray doctrine, they used that doctrine to say that, well, hey, the nation is the true parent of the children. Therefore, parents, when the coverture law was dissolved in 1875, 1876 under the 14th Amendment, that the children were no longer under property rights of the parent, of the father, or either parent, but it actually, that property rights, or the authority, changed from the parents to the government. Does that make sense? So the
Mhm.
14th Amendment, it actually got rid of parents' authority over their own children. And we're starting to see that in the legal system now, right? And we're starting to
Mhm.
see the state started to appoint guardian ad litems. What are guardian ad litems? Guardian ad litems is nothing more than the state saying, hey, these children are wards of the state, so we are going to claim legal authority and responsibility over these children, and we're going to appoint them an attorney who actually who violates the constitutional and inalienable rights of their original parents, right? And so they actually do that, and that was under the juvenile court system, where a lot of these things were practiced and got away with just because the child was too young to practice their own constitutional rights.
Mm-hmm.
So we're in a huge mess. Now, the problem is, historically, men and women have never shared 50% custody, right? It has never historically been done. It has never historically been attempted. Now, that I'm aware of. Now, the reason why is because when you're looking at a divorce is a lawsuit, right? You're suing the other party for breach of contract. And if there's breach of contract, there's penalties. Now, one of the things is penalties is that you would get the custody of the children, you would get the home, you get the finances, whatever it takes to take care of those children. Now, because you would be suing for a breach of contract under the penalties, and the winner, right, would be able to get the claim, the prize, get the booty, get the children. Now, what the problem is that under no-fault divorce, right, where there's no enforceability anymore under legal contract law, is that basically the courts are you're no longer suing the other party for breach of contract when you go to courts. So courts, family court no longer acts as a court, but they act as an administrator, because what they're saying is hey, we're instead of being able to judge who is the injured party, right? They're saying, well, hey, neither party's injured, because when you do a no-fault divorce, you're saying, hey, nobody's injured here, right? And they'll say, well, we use the best interest of the child standards because nobody's injured, so we'll just give the child we'll decide custody according to whatever is best for the child. Now, so that was the premise of the best interest of the child standards. So the best interest of the child standards was adopted with the no-fault divorce. Those came as a package deal. Now, the reason why, as the feminists said, we want to have no-fault divorce, right? They said the reason why we want no-fault divorce is because the proving adultery, or even more importantly, proving abuse in a home, is very difficult, right? Cops for the most part, even with women or children, but they're like, hey, we don't know if you're self-inflicted wound, according to clear and convincing evidence on a criminal legal system, right? The criminal law is that you have to have a witness. Somebody had to witness your husband hitting you, right? There had to be some kind of physical evidence. And a lot of women couldn't come up with that evidence when they filed for divorce, because they were given the right to divorce for cruelty and abandonment and abuse and other things, but they weren't able. They had a hard time proving it, and let alone family court does not use clear and convincing evidence. It uses preponderance of evidence, which we'll talk. It's a lower system of evidence, so the person really wasn't able to be found guilty of a crime in family court, because they didn't use the correct level of evidence. Plus, they didn't have a jury, so you would be able to. So long story short, they use a different legal system. So a long story short is that the women said, hey, we want to be able to file for divorce, but we don't want to have to prove that abuse has happened, even though abuse has happened. So the no-fault divorce system was be able to give women the right to divorce without proving abuse. Now, it was packaged a little bit differently to the legislators in Ronald Reagan, but originally that was the original intent. Now, what it did is a promise. The reason why the men adopted this legislation is because they said, hey, we'll get rid of the tender years doctrine, where 100% custody is automatically given to the mother, and we'll give it to the best parent. So the fathers thought that, hey, this legislation will, best interest of child standard will work for us, because it will get rid of the tender years, the younger years doctrine. And what it will do is to say, hey, it doesn't matter the age of the child, right? It will just, who is ever the better parent. So the fathers thought they were going to get a better shake at custody. So the men jumped onto this. The churches didn't really push back at all. But the men jumped on this because they thought that they would get more custody of the children. So that's why they jumped onto the best interest of child standards, because of or no-fault divorce, because of the best interest of child standards. Does that make sense?
Yes.
I'm sorry, I'm talking a lot of fast because I know we have a little bit of time. But so what happens is that now, according to what happens is if you're not dealing with a suit, right? You're not suing for breach of contract, right? Which is under a marriage license, it becomes under contract law. So if you're not suing for breach of contract, well, then there should be a presumption of 50-50. And that a lot of fathers or a lot of people are pushing for the 50-50 legislation because they're saying, hey, well, we should have, now let 50-50 legislation just says, just under contract law, an example, if you and I own a business, or two people own a business together, and they decide to sell that business, right? They decide they have an opt-out clause in the contract. They decide to sell that business, one person. If there wasn't a breach of contract, right, and there was an opt-out clause in that, or they both agreed to it, then what the court would say, okay, let's go ahead and divide the assets equally, right? So there would be a presumption of 50-50. That's what 50-50 legislation means, that there's just a presumption. However, it's only presumption, so it's rebuttable. But that rebuttable means you need to have some kind of pretty substantial evidence. Now, the legislator or the judicial system, the bar association, the lawyers, and the judges don't want it because the family court makes more money, right? It revolves around the family court than all the other courts combined, right? I think it's like a $50 billion a year industry. And it would just take away a large portion of the financial. It would also destroy the federal fundings that the state gets through the Title IV-D fund, right? Because they get the federal funding for child support. So if you get 50-50 legislation, you're starting to get rid of basically child support, a lot of the child support. Or that child support is only maybe for a small amount of time, like 6 months in some nations. So basically, the federal government would lose money. The legislation would lose power. It would be, and what would happen is the 50-50 is that it would get the courts out of the family's life, right? The children really wouldn't become wards of the state, because if it's 50-50, there's a presumption of 50-50. Well, then you don't need to continually go to court to fight over, where those dividing lines of 50% custody, 75% custody, legal custody, all this, you don't have to fight about that stuff because everything's 50-50. And you would probably do more mediation and arbitration and spend less time actually with the judge. Now, so what happens is the legislators are against this because the women under the VAWA, right, Violence Against Women Act, and other things, is that they actually, the feminist groups and the National Organization of Women, I think they get like 50 million a year from the federal government, something like that. But they're because of how much money they have through the federal government and acts, they are incredibly powerful, right? Feminist groups are incredibly powerful. Now, the feminist groups don't want 50-50 custody because they're claiming that, well, hey, a child will be more likely to be put in an abusive situation. However, statistically, people would argue right now that 75% of children are actually given to the abuser right now, because you're looking at whoever initiates the divorce, either believe that they're going to get the children, or they're actually the initiator of the divorce covenant itself, which is a violation against the covenantal promise that you made to the other spouse. Whatever the case is, usually the one who initiates divorce is the one who actually wins the court case. Because if you think about it, if it's a lawsuit and you initiate a divorce and you're given a divorce, you're considered the winner, right? And as far as lawsuits, if you win, you get the majority of custody and the financial and all the other incentives, right? The booty. So if you're initiating a divorce, you get the divorce, you get the booty. And so you're looking at around 75%, I think, or something like that. I heard is that they're the ones who initiate divorce 75% of the time are the ones who actually get the custody or get the majority of the winnings in a divorce situation. Right now, we're looking at around 83% of women are them getting the primary custody of children. Divorce, about 75 to 80% statistically, women are initiating the divorce because they know they're going to get the children. But more likely, the women who actually file for divorce who have children are the ones who actually get the children. I think it's like, I heard one report from Stephen Baxterville, I believe, that he said it was like almost 100% of the time that the women who have children and initiate divorce, they're the ones who get, custody like 100% of the time. So we got this whole gender war. Now, the thing is that gender war cannot stop. They're thinking that under contract law, because of the enforceability factor, right? Unilateral no-fault divorce is unconstitutional. The reason why is because under the contract clause, or there's a contract protection under the Constitution that says that that the federal government cannot infringe, right? Government cannot infringe on private contracts. So when you're getting a marriage, you're actually making a private contract. Now, the marriage license was a way for the state to be able to say that, hey, you're actually making a license. The state is a third party, and they're giving you, and whenever you get a license for anything, right, hunting license, driver's license, you're really saying, the state is really saying that it's not an inalienable right, it's a privilege, right? And we're granting you the privilege to do this. And so there basically really is, when you have if you have the power to say no, you actually have the power. So the question is, who has the authority in a marriage when you get married? Well, the state's claiming that we have the ultimate authority because we have the power to say no, right? The veto power. So it becomes a marriage license, and then they also get they make children wards of the state through the marriage license, as well as they're able to control the divorce process through the marriage license. Mm. Do you have any? Sorry, I know I'm talking a lot. Do you have any questions so far?
So things had flipped. First, women were getting custody, and now it's kind of flipped. Then the men were getting the custody. Then it flipped back to the women getting the custody. And now it seems like it's reverted. The pendulum has swung back, and now the fathers are getting the custody.
Right, and then you're going to see that not the fathers are getting custody. So, right, statistically, we know that 83% of primary custody is, like in Minnesota, 90% of primary custody is given to women. Because if you know you're going to get the children, you're going to initiate the divorce. You're less likely to initiate a divorce if you believe statistically you're going to lose those children. So the ones who initiate, petitioner is the one who usually is the one that know they're going to win, and that's, like I said, 75-80%. Now the problem is, when it comes to actually physical abuse, right? To protecting women, to protecting, more importantly, the children. Now, we're in a culture where we have a God, and that God is sexual, right? Is a sexual God. Now, Los Angeles actually means fallen angel, right? Kind of thing. And through Los Angeles, right, we see a lot of our movies, right? The sexual perversity. Now, what happened was, feminism, they wanted sexual perversity. They wanted the women. You can read it in all their transcripts. Is that they wanted to destroy marriage. They wanted women to still be permissible, sexually promiscuity. They wanted sexual promiscuity. They wanted to be, my body, my choice. And they also wanted the ability to abort, because if you get pregnant, right, and you're not married, all of a sudden, you're bound in chains. So the feminists believe that, hey, we need abortions, a right to abortion, to be able to free ourselves, so we're never chained down, right? We always have the freedom to express ourselves sexually, to be able to legally take control of ourselves, destroy coverture laws. So when it comes to the home, like a stable home, feminists don't like stable home. They say marriage is an institution, yes, but it's still an institution, right? And that's what feminists will tell you. So they don't, and because of women now, like Black women right now, statistically, 40% of them are getting pregnant out of wedlock. Well, they're leaning on the government for help, right? And so now we're putting a great financial burden and strain on the government. The government says, well, we don't want the financial strain. So they created the child support system, and they created the deadbeat dad propaganda to be able to get fathers, right, to pay for these kids that they don't even have a right to visit, or don't even have a right to see, and they don't have any legal rights to decide, where the kids go to school, college, sexual or any kind of operations, and so forth. So now the legal system is correct. They'll never say this, but under their breath, they believe that that if two people, men and women, cannot get together married, they're not going to be able to get together. They're not going to be able to get along divorced, right? And that's true, right? Not only do we have gender differences and different ideals in the way we think and process things, right? But a lot of us are, if we're not saved or we're not Christians, we're sinners by nature, right? And the majority of people we know in the world by Christ, that the majority of people, right, broad is a gate, and broad is the way that leads to destruction, but narrow is the way that leads to eternal life. So we know that the majority of people in this world are going to be unsaved and they're going to be slaves to sin. And so there's this sinful nature. Now, according to the Bible, the children that even sinners, right? God says that if even you who are sinners, you don't give bad things to your children, you give good things to your children. If they ask for bread, you don't give them a serpent, right? Or you don't give them a rock. And if they ask for fish, you don't give them a snake, right? It says you who are ungodly, unloving, unbelieving people, you still know how to give good things to your children, because you'll die for your children. Even unbelievers will die for their children. However, the state doesn't recognize that. The state's saying, well, like it started in, a lot of times, like in Massachusetts in the 1600s, they were taking children away from parents because they didn't have children labor laws. So if the children were not working and children were not working in a way that would be productive for them later on in life, they would take those children away from their original parents and give them to different parents to be able to put them in the workforce where they can do something that maybe had productivity, because education wasn't as big during that time. So, but the state has always been about not only taking control of the children, but be able to redistributing the children, right? And we have that huge problem, because we have 500,000 children in the foster care system today. You know, Trump recognized that. He realized it was a problem, and he promised he was going to do something about that. He was actually talking about giving Ivanka Trump the power to look into it. But he did recognize that the great system. Now, the reason why is because the government's getting involved. The government's splitting, taking away children from parents. Now, what people don't realize is that if you're, by nature, if you're a lion and you're going to attack a herd, you don't go after all the animals, right? You find that one who's weak, right, and the one that can't take care of themselves, and you attack them. And so you always get the stragglers. Well, the government does the same thing with children, right? The government, what happens is a divorce happens. A mother statistically will get custody of the child. The mother's working full time, right? Because she always hires. They usually hire lawyers. Women usually hire lawyers. So they're trying to pay the lawyer fees. They're trying to pay for their own. They're trying to be able to get a career after being a mother for certain years. And what happens is they have a hard time raising the children, right? They have 3 kids, 4 kids on their own, and they just don't have the time, they don't have the hands, they don't have the finances to pay for it, right? So what happens is that the government then swoops in because somebody files a report. Usually the school system, the majority of child protection service investigations are done through the school systems. And so they'll see some of the school, the child will say something, the child will look malnourished, have a bruise, whatever the case is. They're mandatory reporters. They call the police, or and Child Protection Service comes in, and they say, hey, this mother can't take 4 kids, 2 kids, and raise a job and everything on her own. Let's go ahead and redistribute the wealth. Let's redistribute the children, and let's get the children into a foster care system until we can actually get them into a good home. They did that and with the American Indians. We had a huge problem with the American Indians originally. They were taking the Indians' children away, giving them to white folks. And it was a huge, huge problem. That has now been somewhat corrected. But the government has always been about redistribution of children. Get the children away from. Now, what happens with the high divorce ratio, right? We're looking at 40, 50%, the divorce ratio, and even more people are getting married. People don't know this, but the cohabitation increased 900% since, I believe, 1980. Or actually, apologize, 1969. So what happens was, even though in 1980 it looks like the divorce ratio has been going down, the reason why is because the cohabitation rate has skyrocketed 900%, and people are having children out of marriage, right? In cohabitation. But the parents, and they don't really worry about that, because a lot of times the women could still attack the men to be able to say, we want them to be financially responsible. And the federal government has created federal mandates and laws to actually say that a father can't jump ship. He can't go to one state to a different state to be able to escape child support. So the women know that they're probably going to get either financial support from the government. So what happens is, a lot of people talk about this, is that when a woman goes through a divorce, she still has a husband, but her husband is the government, right? She relies on, the thing is, the government doesn't tell her what to do, right? So she gets a little bit more freedom with the government, but she still gets the financial provisions and protections from the government. But what the government says, but the government is tricking the women, because the government's really saying is that, All you have to do is file for this divorce or have a child wedlock, or just go ahead and submit something to the court. But as soon as you submit something to the court, that child's no longer your child, right? That child is no longer under the constitutional rights of your extension, right? Or under the property laws of you anymore. The child is really under parents par tre doctrines. They belong to the state. As soon as you file anything with your family or with the children, the state is going to swoop in and be able to get and ruin that privacy that's guaranteed through the Constitution, right? Our privacy rights, and be able to control the child, not just for the time being, but forever, as long as the child remains a child. And so, anyways, we're in a situation that the courts don't want to give 50-50 custody, right? The courts realize that historically, men and women have never been able to get along. If they won't be able to get along in a marriage, they won't be able to get along in a divorce, right? So, and they're less likely to get along in a divorce. So what happens is you're dealing in a system that there's almost no way to fix this, right? The only way to fix this would be to revert back to the patriarchal system that we see in the biblical principles, right? The Bible. But however, the courts of feminist groups and everything else is pushing against anything that looks like a biblical marriage, biblical relationship, biblical family. But that's the only way for us to be able to create some kind of normalcy and protection of the family and protection of the children.
Well, this is a big mess.
It is.
It's the judges don't want to hear. I mean, even if a woman has a lot of documentation of domestic abuse, then the other side will come up with something else, and the judge will hand the child over to the abusive parent.
Statistically, they say 75% of kids are given to the abusive parent. Statistically. Now it's hard to prove those statistics, but most people believe that statistically, right? Because if you're looking with a narcissist, you're looking at an abuser, somebody with mental problems, is that typically in the Bible it says we worship God in our own image, right? Well, the judges are going to give custody to somebody who looks like them, who acts like them, who thinks like them, and talks like them. So when the judge sees somebody comes in with the narcissistic and all the other stuff that they have, the judge is going to say, I have that. I like that. I know I'm a good parent. They must be a good parent too. And they're giving these kids to these abusive narcissists, and they could be either mother or father. But now we're finding out is that the judges, because of the fathers' rights movement, is pushing against these false allegations. But what they're really doing is they're attacking the innocent women, right? And they're giving the children to the guilty women. And it's just, what happens is, under preponderance of evidence, you really can't do this. You got to have a jury. You got to go through the criminal system, right? When it comes to abuse, neglect, those are crimes. They have to go through the criminal system, because the criminal system is more likely to use evidence and use witnesses and testimonies and juries. But when you go through the family court system and you skip all that stuff, there's no way the judge, who is untrained in psychological matters, they don't have a degree in psychology or even the medical field, they're not going to be able to say if a child's being abused physically, sexually, or mentally or not. And they're trying to be able to say, well, I'll have a friend of mine, right, or somebody that I know, be able, who's a psychologist, look at it. But then you're creating a monetized system where they're just going to be these therapists a lot of times are saying, well, if I like the judge's business, I want to make sure I please the judge. So I want to make sure that I judge in a matter that's worthy of the judge's, consent. And it just creates a corrupt system. Not saying they're not educated, but what it is creating a corrupt system. We have to realize that when it comes to criminal matters, those have to be handled in criminal court. They cannot be handled in family court, and they simply can't. And just recently, this year, California judges are now given extended powers where they actually can choose. They can choose how supervised visitation will look like, most likely with the fathers. But again, this is a system where it's corrupt because it is monetized, and there's not checks and balances. Checks and balances doesn't mean a judicial committee overlooking judges, because that's just like saying, hey, I'll have my friend down the street, tell me if I'm doing something wrong. No, you want to be able to have somebody who's non-biased And it has to be through a checks and balance system where that, just like the branches of government, it has to be somebody who's actually is against you, who's looking at this. It could be more, or that to be able to get rid of that biased decisions. But long story short, yes, you're right. The judges are now taught to, when a woman comes in frantic and she's screaming because she loves her children and her children are getting raped, getting abused because of the sexual culture that we're in, they're less likely to be believed. And judges are going to be looking for people who seem to be non-sympathetic, who are creating abuse or yelling abuse, rather than the people who are frantic and sincerely care. And that's historically, statistically, that we can literally see. So it would be very hard pressed to prove anything against that.
Well, I mean, this was excellent. This was an excellent history lesson and everything that's going on in present time as well. It's just, I just wish mothers and fathers who are getting screwed over by the system would work together to try to find a way to, I don't know, fix it or not bash each other.
Right. Well, the only way is to be able to get the power away from the government, right? So there has to be a recognition that the children are part and parcel of the constitutional rights of the parents again, and that the government, once they make a decision, they cannot continually to put their foot into the parents' lives, because that violates the privacy rights in the state constitutions as well as the federal constitution. The premise of the 14th Amendment, not due process right, but the substantive right, substantive, I think it's called substantive right of the 14th Amendment, where it actually, like an example, Roe versus Wade, where they said that the government cannot jump in because of privacy issues. There's the home, and under the many Supreme Court cases, is that there has to be a privacy issues. You can't do gag orders. You can't do orders of protection, right? If somebody breaks a crime, you throw them into jail, right? And you extend that jail time the more that they commit, right? And then you give them 3 strikes and you're out. And we already have the legal system to handle it. The family court is trying to handle all matters of the family and life, and to raise those children and say what's best for those children, but they cannot do that. That's not what they can't have. They're already, they just, long story short, we got to go back to the biblical principles of family. We got to stay together, stop initiating. If you don't believe in the concept of marriage, don't get married, right? But you also can't be a sexually promiscuity because otherwise you're going to start having, a child out of wedlock, and many other things. And that still creates an inalienable right problems, So again, the only way to fix this, we got to go back to the biblical principles of family and relationships and marriage, and start respecting what a covenant is and that covenantal promise that we made to the other person. If we've been divorced, we're just inviting the government into our home.
Oh, exactly. No, yes. Well, I'm so glad to have you on, and I know I'll have you back on again.
Thank you. Yeah. Oh, yeah. God willing. Yeah.
I think this is like the 5th time you've been on my show.
Yeah. I think you're right. Yeah, absolutely.
Yeah. Because we also talked about Woe to the Wedding Band, and I think people should listen to that podcast as well. That was
I love it. Yeah. Woe to the Wedding Band.
Well, hey, don't jump off. Slam the Gavel is a podcast to help the public understand what really goes on in the family courtrooms. I am your host, Maryann Petri, author of Dismantling Family Court Corruption, Why Taking the Kids Was Not Enough, and Cry Out for Justice, Poems of Truth. Please join us here again with Michael and other guests in the future. Thank you again, Michael.
Thank you. God bless you.
Thank you.